Welcome back. My name is Patrick Nolan. I'm an attorney licensed in the state of Missouri. This is Pat Talks Law. Well, I'm back behind the wheel again. It's good. It's also bad. I'm driving an hour and a half to go to court. Fortunately, everything's in the same court all day long. Unfortunately, everything's in the same court all day long. Yeah, it's a busy day. This will be the last day I'm representing that particular client. And the last day I'll be running, well, not the last day I'm representing that particular client, but the last day I'll be running all of the cases on this particular docket call. So I'm happy about that. I'm also a little sad because I really like the client. Just sometimes things change. So today I want to talk to you about something that a lot of people overlook. They don't understand and they get upset about, and that's the discovery process. Okay? If you are in a court case against somebody, there's a process called discovery. That's where you find information. You send the other party what's called interrogatories and requests for production. The other party sends you interrogatories and requests for production. Then you fight those out. You answer all the questions. Your attorney looks and sees if there's any that are objectionable. They object to the objectionable stuff. But something that gets overlooked a lot is you still need to answer the question to your attorney because, excuse me, these temperature changes up and down are playing hell with my sinuses. You still have to answer the questions to your attorney because they need to know the information. They need to know if it's something they have to prepare for, if it's something they have to prepare to fight, what might come, what surprises they might get hit with. The attorneys have to know. Also, it helps clarify the case. When you're answering your interrogatories and your requests for production, and the other side asks for, let's take example of divorce, all the acts of misconduct that you are alleging. If you don't list them all out in particular detail, you may not be able to introduce those in court, which means your argument might fail. You know, you could say this person is the worst thing in the world since, you know, they started slicing bread. You know, I don't know. But your argument may fail because you may not be able to get those arguments in because they weren't disclosed. The other side will argue surprise, although, I mean, is it really a surprise that he beat the snot out of her? Yeah, probably not. But that's the argument that a competent attorney will make. That it wasn't disclosed in discovery, the testimony is exceeding the scope of discovery disclosures, and you may not be allowed to talk about it, and any reference to it will be stricken. So, you have to actually write it out. You can't just say it's obvious, or I've already said this 3 or 4 times, or I told her, I called the cops. You have to spell it out again, in detail. Now, that gives you an additional chance to re-remember and refocus on what happened, so that you have a better and more coherent answer when you're asked about that at trial. It gives your attorney things to focus on and narrows the breadth of the case some. That saves you money. Now, the flip side of that is if you don't answer and they accept that, okay, fine. That's a problem. If there is you don't provide the documents requested in the request for production. If you don't produce it, you can't use it. If you don't produce it and you don't have a valid objection, they're going to haul you in on a motion to compel. That's they're going to say, Judge, we asked for this. They've refused to produce it. We want you to hit them with sanctions. I want them to pay for the cost for this motion and hearing, which is sometimes ordered. I want the documents in 10 days, or I'd like their pleadings to be stricken and a default judgment entered against them. Okay? That does happen. I have successfully gotten that for clients. So, you have to be ready to answer the interrogatories and requests for production. When your lawyer says we have 30 days, you have 2 weeks. What your lawyer means is you have 2 weeks to fill out all your answers, get it back to him so they can go through them, bring you back in, and redo some of your answers. Because chances are you will not have disclosed enough, that you would need to disclose more. Most people under-disclose. Almost nobody over-discloses. So you have to have time to work on that and get the information that's needed. You know, some questions they know the answer to. They just want you to admit it. Some questions, it's a fishing expedition. You know, the other side doesn't know the answer. They just want to see what you're going to say. Yes, they can do that. Yes, we do that. In the discovery process, you can ask anything that's reasonably believed to lead to admissible evidence. The question itself doesn't have to have an admissible answer, but if the answer would lead you to something admissible, then it's acceptable. A lot of people, in divorces particularly, don't want to spend the money on depositions. Depositions are important when the case is heavily contested. If one side is talking about having expert witnesses, deposition is critical. You have to depose the expert witness. Had one case, the other side claimed they had an expert witness. We believe that witness was, in fact, a lay witness, a family member of the other party. At deposition, despite the attestation that this person was an expert witness, they testified that they weren't. They'd never been consulted, never been asked. So despite their having been disclosed as an expert witness, that was not correct. The other party flat out lied about it, or the other attorney just flat out lied about it. So when we deposed that person, we asked about their history, we asked about their CV, and we deposed 3 people that day. There was only one I cared about. So we asked about that, and we found out that they were not in fact an expert witness. They were just a lay witness, and that's fine. I mean, you know what a family member of the opposing party is going to say, right? Whatever their family member wants them to. So you don't need to worry about that. That's a given. But once we determined they were not an expert witness, we asked the court to order attorney's fees for the deposition, because the only reason we had it was because they were disclosed as an expert witness. The judge didn't, but they were also barred from testifying as an expert. So that was definitely a win. Now, we have had discussion about discovery with a lot of clients, a lot of them, and it's always the same. Man, what does it matter if I got a new girlfriend? Well, it matters. The other side thinks it matters, it matters. If you're in a divorce, it matters. Now, let's talk about discovery on a criminal side. So we're going to flip this a little bit. If you are a criminal defendant, the prosecution cannot depose you. You cannot be forced to testify. If you testify, they can cross-examine you. So there are times when a defendant should not testify. There are times when a defendant absolutely should testify. And that's something you need to talk over with your attorney. There's a lot of evidence that you can't get in unless the defendant testifies. There are categories of crimes that, unless there's some overwhelming reason the defendant shouldn't testify, I think they should. I I personally am of the opinion that I think juries want to hear the defendant say, quite plainly, I didn't do it. Now, that's risky. If you got a criminal history, it's risky because your criminal history is going to come out. You could be convicted by a jury because they don't like the fact that you got a criminal history and you're still getting in trouble. And that's something you have to talk out. That's a strategy decision. You discuss this with your attorney and you make the decision. Do you want to testify or not? But you need to do that rationally. As far as discovery, you do have to disclose in criminal defense certain things. Now, if you're going to be resting on an alibi, you got to tell them what your alibi is. You got to do it. If you are pleading self-defense, okay, you're going with an affirmative defense, and there's a list. Your attorney's going to know this. They're not going to give up the freaking. They're not going to call a prosecutor and say, "Hey, Bob couldn't have robbed, committed that misdemeanor assault because he was busy robbing the bank at the corner of 5th and Main." Your attorney's never going to do that. If they do, oh God, that's a completely separate discussion. So, as far as discovery, every case, and it's bigger with civil, has discovery. On the criminal side, the state's got to provide you everything they got. They're also required to provide you any exculpatory evidence they possess. That's evidence that could be used to argue that you didn't do it. They have to present, if asked, any what's called Giglio Evidence. Okay, the exculpatory is Brady, and Giglio is a history of law enforcement misconduct. They're the officer's misconduct record. That's usually fought quite heavily, and you usually don't know about it unless your attorney knows about it, because there are very few prosecutors that voluntarily turn that over. So you have to know. I'm not going to get into that. I have some active cases. I don't want to discuss the detail that might harm an active case. But if there is evidence of misconduct by an officer in his record, you have a right to look at that and see, does that history of misconduct impact this case? For example, if an officer lies under oath repeatedly, they've been called out, the court sanctioned him for lying, that's kind of an important thing. If he lied under oath before, he'll do it again, and that's information the jury needs to have. If officer planted evidence on somebody, your guy is saying, it's not mine, I didn't do it, I don't know where it came from, it's not mine, and this officer has a history of planting evidence, okay, that's something the jury needs to know about. Now, I will say, in most of the jurisdictions in which I practice, a cop that does that kind of stuff ain't going to stay a cop. Not there. But it happens, and you need to know. I mean, Missouri is a pretty big state. Somebody might give that person a job. So, when we start talking about discovery, anything that's reasonably calculated to lead to admissible evidence can come in. But you have to be completely honest with your attorney. You have to tell your attorney everything. I had a client one time that talked to me, told me about their threesomes and and all their activities that I thought I knew. They laid everything out they told me they laid everything out that might be used against them. We get to the trial, and the first question in trial is that they misreported their income. They neglected to tell me or report income from their online chat girl porn station. So, I didn't know my client was a porn star. That's not the revelation you want to get during trial. That case settled. We took a break and the case settled. It was a horrible, horrible, horrible case. I was furious. But, you know, you gotta know, and I didn't know. One time I had a client move out of state. Didn't tell anybody. Yeah, that's also a bad thing. If you flee the jurisdiction, you know, that doesn't go well. Courts frown on that. But sometimes, man, I mean, it works out. You get in the discovery process, you find nuggets that you can use. Had a guy that was charged with drugs, and in the course of our investigation, you know, he said he was a war hero, and I'm like, yeah, okay. A lot of people say that. I mean, I'm a combat veteran. I'm not a war hero. I'm just Joe to do his job. But, you know, a lot of people say that. They pump up their record. Well, we went back, we looked, we found his record, and holy shit, he was an actual war hero. I mean, yeah. So then we were able to use that. Now, we got the guy out of jail. Oh, God, he disappeared for 3 years. You know, he was on the lam for a couple years. He came back, and because of what we found, and because of the other stuff we found about him, we were able to talk to the prosecutor and get a really generous plea agreement. And that plea agreement, you know, got the guy treatment, got him in with the VA. You know, we were able to really help this guy. And he's doing quite well now. So, discovery is important, and your attorney needs to know. Okay? If there's a warrant for you from another state, we got to know. If there's, you know, an ex-wife that'll say anything to put the knife to you, it may have nothing to do with this current case, but we got to know. You know, a lot of people can speak at a sentencing hearing. If the information they have to provide the court is relevant to what sentence the court might pass, then they can speak. So we got to know. We got to know what's going to come out. Discovery is not where you short. You put the time in, you answer all the questions, you answer them fully and completely, and you spend the hours. The more hours you spend preparing your discovery answers, the fewer hours your attorney has to spend. That will save you a lot of money. It could save you money on your civil case. It could save your freedom on your criminal case. The little detail your attorney doesn't know might be the difference between going to prison, getting probation, going to prison, or walking free. You know, and it's small details sometimes. Had a case, and the case ultimately came down to which way the door was hinged. Okay? It was a domestic assault. Guy was charged with a whole slew of offenses. But ultimately it came down to us being able to disprove the complaining witness's version of the story, because the doors leading into a bedroom were hinged at the corner. This one opened that way, this one opened this way, and both doors couldn't be open at the same time. We were able to show that. We were also able to show that she had tried to call off from work and used the alleged incident as her excuse. And then her boss insisted that she file a report with the police department. So she did. Now, we got a not guilty on all counts in that case. But little details like the conversation with her boss and, the phone calls she made reporting it. Those are small details, but they're very important. That actually was the motive for her to lie. Okay? Yeah, we don't have to prove my guy's innocent most of the time. We got to prove the state didn't make the case. But juries want a story. They want something they can understand, and they want something simple enough to understand. Discovery is how you get there. This is getting too long, so I'm going to log off now. Hit like, subscribe. Thanks for watching. I'll be talking to you again soon.